Radio Al Ansar and the Al Ansar Foundation.
Business Matters. The title suggests many things. The important issue is the world revolves around business. Society, organizations, individuals, and even religion survives and thrives because of business. Business has to encompass not just financial commodity and service transactions. It has also to include welfare, justice, empowerment, environmental, and other issues too. Every week, Business Matters will delve into aspects of business that impact our lives. We will seek out extraordinary and ordinary people who have done extraordinary things. Facilitators, educators, and entrepreneurs will be invited to inspire and enlighten our listeners. Join Anwar Moolla for an interactive show and find out what really matters in business.
نحمد ونصلي على رسول الكريم أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم السلام عليكم ورحمة الله وبركاته. If you just joined us, it's just gone 7:20. You're on Radio Al Ansar, yes, and it's another Business Matters program. Business Matters brought to you by the Minara Chamber of Commerce. If it's Monday evening, then it's got to be Business Matters, and thanks for joining us. A really exciting guest in the studio with me tonight. We're talking about the gig economy, how gig economy and contractor rules impact local employers. Something I don't know too much about, but he's certainly going to fill us in. So it's welcome to the studio to Muhammad Aman Mirza. Muhammad, assalamu alaikum. Welcome to Radio Al Ansar.
Jazakallah. Walaikum salam, Anwar. Thank you for having me.
Muhammad, lovely to have you here in the studio. First time you said you're in the studio. So yeah, relax and we'll have a great discussion around the gig economy and contractor rules and how they impact local employers. Mohammed, tell us a little bit about yourself, your upbringing. Has it always been in Durban? Have you Durban born and bred? And a little bit about your educational background.
Sure. Spot on. I'm Durban born and bred. I went to school, high school in Durban High School, DHS, matriculated there and then went over to UKZN, did my LLB degree 2016, 2019, finished up. And that was just about, in 2020, COVID kicked in. So during that 2020 year, I had a bit of a lull, I suppose, a bit of a break, if you want to call it that. And then straight after that, I joined a global law firm to do something what lawyers call articles, practical vocational training for 2 years. Spent my training there, learned a great deal, was really surrounded by great people, people who really knew their job, good lawyers. That probably puts me in the position to talk about or have this discussion with you this evening. So I spent about 3.5 years there, then joined another smaller firm. And then alhamdulillah, earlier this year in about July, I opened up my own practice called MIRZA and Associates. And we're based in Overport, next to Overport City in Gem Towers.
Okay.
So I've been working for myself now for about 6 months.
Okay.
And we specialize in this sort of work. So I'm really excited to have a discussion with you today.
Yeah, nothing better than working for yourself. And I think you've got enough of experience now that you've built up with working with other legal firms. So we wish you everything of the success in your legal world. Lawyers keep complaining that they do all the work and they don't get paid. So I hope it's different for you.
I hope so too, inshallah.
We're talking about the gig economy, something that I'm not too familiar with. So in simple terms, what do we mean by the gig economy in South Africa, and how is it different from traditional employment for local businesses?
Okay, perfect. I think the easiest way to describe it would be, and I know we're a Muslim radio station, but everyone knows the term gig, like a music gig, or, do you have like a gig for the weekend, or do you have something to do on the weekend? And that's exactly what it is. That gig will last for a weekend, or it'll last for a couple of hours, or for a defined period of time. And that's exactly what the gig economy is made up of. It's made up of individuals who perform either a defined scope of work for a particular project, or perform a function for a defined period of time. And legally speaking, that would be by way of a short-term contract, and performed by a freelance employee or freelance individual, not employee, a freelance individual, like I said, for a specified duration and a specified period of time on a particular project. And so there's no formal contract between them and the employer, or them and the business. It's really just come in, perform this function. If it takes you half an hour, it takes you half an hour. If it takes you 2 days, it takes you 2 days. And that's what it is. There's no formal employment relationship or formal contract governing that relationship between the parties.
So how would that be different to, for example, getting in employment on a part-time basis, if I can call it that, where at times of the year you may be busy, so you need some extra labor, and in other times of the year you're not so busy, so you don't need them. Would that be classified as gig labor, or how would you classify that?
Yeah, I mean, look. So if you take on a group of individuals for a busy season per se, you take them on as employees for a defined period of time by way of a fixed term contract, let's say from December till the end of January. Now, those are employees. An individual who works in the gig economy isn't defined as an employee. They're just an individual rendering their services for a defined period of time, and they aren't sort of regulated by any piece of legislation, by the law, or any sort of contract. I can call it that.
Okay.
So that's the key difference. They're an independent contractor, which aren't, so to speak, governed by any contract with the employer, whereas an employee is governed by a piece of contract, legislation, and other pieces of information.
So Mohammed, why does it matter so much in law whether someone is an employee or an independent contractor, and what changes for the employer in each case?
Okay, so that's it's quite a loaded question, because as an independent contractor, the reality is that that's someone who works for themselves. They have their own business, they render their own services, and they don't necessarily work for the company to which they render their services for. Whereas an employee works strictly for that company. They only render the services to that company. They come to work at a certain period of time. They only get paid by that company. And so they rely solely on that employer for their work and for their salary. Why it's important is probably for the rights and responsibilities for each parties.
Absolutely.
Now, so like if you're an independent contractor, if you're someone in the gig market or the gig economy as we call it today, you aren't necessarily protected by any piece of legislation. So the Labour Relations Act, the Basic Conditions of Employment, National Minimum Wage Act, Employment Equity don't apply to you as an independent contractor. So, I mean, a very common example is if an employee is unhappy, they go off to the CCMA. If you are an independent contractor working in the gig market or the gig economy, you cannot rush off to the CCMA or to a bargaining council. You aren't an employee. You're an independent contractor separate from the company. And so that's probably one of the key differences, the key important aspects to keep in mind, that aren't considered an employee, unfortunately. That's a key difference.
So from an employer perspective, I mean, having these people working in what you would call the gig economy, would it not be better for them? And I'm saying this tongue in cheek because they would be able to get away from some of the responsibilities that go with being an employer.
Absolutely. Now, the reality is that as an employer, you cannot, just constantly keep on renewing a fixed term contract or keep on renewing an employment contract with an employee who is an independent contractor. Now, that's one aspect of it. The other aspect of it is that, I think we might touch on this a bit later, is that if you treat an individual like an employee and they walk and talk like an employee, the Labour Relations Act and the Basic Conditions of Employment have have provisions in place that will deem that individual an employee and effectively place them in the position that they ordinarily would have been in, even though you treat them as an independent contractor or an employee in the gig economy. So it's really form over substance. You can say whatever you want, you can do whatever you want, but if they work like an employee, talk like an employee, the law will consider them an employee.
So give us typical examples of businesses or people that would employ these people that would be termed to be in the gig economy.
Okay, so an example that would probably stick out to you, or you'd probably be able to think about quite quickly, would be, Uber, for example.
Right.
Uber Eats, Mr. Delivery. Those delivery drivers work in the gig economy. They don't necessarily work for Uber South Africa, but they're affiliated with Uber. And if they get a notification, they register with Uber, they log into their system, they sign up as a driver, someone puts in an order for a takeaway, one of these drivers click yes, they accept the ride or they accept the delivery, they'll collect the parcel from the takeaway and deliver it to your house. That's an example of someone working in the gig economy, but not necessarily protected by legislation or the basic conditions of employment or any other protection for employees.
So a person could be driving a vehicle and being basically part of Uber, if you want to put it that way, for maybe years.
Absolutely.
and still have no protection.
Absolutely. So I don't know if you came across the judgment. This happened about probably in about 2020, maybe 2019. I could get my dates wrong. So a group of employees tried to do that. They actually took Uber South Africa to court to say that, look, we've been working here for an extended period of time. We rely on you for our livelihoods. We rely on your business. We effectively report for duty between X hours of work. And unfortunately, in that case, the CCMA ruled in their favor, but on review in the Labour Court, technicality arose, which was that these employees actually contracted with Uber Netherlands and not Uber South Africa. And so it was difficult for the court to actually make a determination on that because we were, the matter was sort of kicked out on like a technicality. And so the law is still developing in that sense. But you're right. Those guys could work for years and years and years for Uber and still not be considered employees at the moment.
Okay. What practical signs should an employer look at to decide if a gig worker is actually an employee?
Okay. So employers run businesses. They're business owners. They don't necessarily know exactly what they need to look out for. And to their benefit, they've got lawyers for starters. But if they just did a little bit of digging and a little bit of research, you'll come across certain sections in the Labour Relations Act and the Basic Conditions of Employment Act. Now, those two acts set out a set of requirements. Well, not a set of requirements, but a list of factors. There's 7 of them. I won't go into the details now.
Right.
They're there. There's Section 200 of the Labour Relations Act and then Section 83 of the Basic Conditions of Employment. And they simply say that, there's 7 of them, and they set out them in a sequential order. And it simply says that if an employee meets one of these factors, a presumption is created that they are indeed an employee. Now, presumption is not to say that it's set in stone, that this is an employee. All it means is that the onus now shifts to the employer. And the employer then has the duty to demonstrate by way of evidence that this isn't an employee, but in fact a contractor for X, Y, and Z reasons. So it's not necessarily something an employer needs to go looking for. It's there in our law, and almost like a tick box exercise. For example, I'll give you an example, right? Example is, if the first one can be, the person's hours of work are subject to the control or direction of another person. Now, employee doesn't need to go looking for that. You can think about his workforce. For example, Asif sitting with us here today, his hours are set out by the radio station. You don't really go look too far. You can say, well, that sounds about right. We have to come in at this time and leave at that time. That's pretty much an employee from the point of view. And then you have to obviously now use the reverse onus, which say, well, it's not really employee for these reasons. So that's a simple example, but it's there for us. It's easy to look at.
So from an employer perspective, why would they want to not treat a worker as a permanent worker? Is it simply to bypass the onerous conditions of the Labor Relations Act, or or is the gig workers generally cheaper, or why would they want to do that?
So I don't think employers don't want to employ an individual or just to make use of the gig economy. I think as much as employees like safety, and that's what a job gives you, give that safety and stability, employers also want stability in their workforce. You don't want an occasion where someone comes into work on one day and they don't come in the next day. And so it's probably not necessarily a case of employers not wanting to comply with the Labor Relations Act or any piece of legislation to formally employ that employee. It's more just a case of perhaps trying to, and I want to get this right, they try to do what's best for their business. And that's what I've noticed in my practice. A lot of the time, my clients want to do what's best. And I mean best obviously from a revenue point of view, but also from a practical point of view. They don't want to have too many employees on their books because one, it's expensive. If they work in an industry which is quite risky to people's health, then it's obviously from a risk point of view. Obviously, there's a big wage bill. If you're part of a bargaining council, you need to pay levies for each employee. So employers, they want to do what's best for their business as well. So they often bypass things inadvertently because they're trying to get to an end result quicker. And people want work. People will sacrifice, a formal contract of employment to just work. And maybe it's a combination of those two things. But I wouldn't say that employers try to get around, really formally employing individuals.
Well, what is the situation with, for example, a PAYE and UIF and things if you've got a person that's working as a gig worker?
Yeah, and that isn't your responsibility.
Is it?
Yeah, that's not your responsibility. I mean, they're effectively rendering a service for you. I mean, it's like someone, like an Uber driver. I mean, they collect their revenue. Their duties on them to disclose their income to SARS if they earn enough money, deal with their UIF, deal with their pay as you earn. They're paying SARS. If they want to sort of comply, the onus is on that work in a gig economy to do that.
So, in your experience, these kind of gig workers, are they more on the lower level of the salary scale, or you see it across the board?
I think it's growing. It's growing. I think a lot of people are going. So the gig economy is not just for lower income earners. I think that's where sometimes we're mistaken, because that's probably where the most attention goes, because those are the people earning below the minimum threshold. That threshold of 21,000 rand. We obviously hear it flying around, but that's the minimum threshold that's set out in the Basic Conditions of Employment Act.
Sorry, come again. Can you just explain that?
Sure, no
21,000 rand.
So often the Labor Relations Act and the Basic Conditions of Employment Act will say that these requirements or these factors or apply to an employee earning below the minimum threshold. So the presumption that I spoke about earlier, the presumption about an individual meeting one of these criteria to be deemed an employee only applies to an individual earning below the minimum threshold. So the minimum threshold is about 21,000 rand a month. I get the exact figure eludes me at the moment. So it applies to employees, earning probably lesser income. And to your question, we often find that, the gig economy focuses on those employees, but I wouldn't say that it's solely on employees on the lower income spectrum, but they definitely get the most attention because they're most at risk of being exploited. And that's probably why the gig economy is such a conversation at the moment, because those employees get exploited. There's no minimum wage that you have to pay them. There's no rights that they have. There's no protection that they receive. They can't rush up to a bargaining council of the CCMA. And so that's probably why this discussion is more and more relevant, especially because a lot more people are involved in the gig economy these days, rendering their services some way or the other.
Well, when we get quoted the unemployment rate in South Africa, and it's running very high at over 30%, closer to 40 actually. It it's mind-boggling that the economy can survive when you got close to 40% of your people that are so-called unemployed.
Yeah.
But they also in the informal economy, a lot of them. And I would imagine that a lot of them are in what you would term the gig economy, because they would not be counted as employed people.
Exactly. That's to your point. I mean, that makes a lot of sense. I can't disagree with that.
So what are some of the most common mistakes you see South African small and medium enterprises making when they use freelancers or delivery drivers or what you term as gig workers?
So, to say mistakes would be difficult to say mistakes. I think what would be more accurate is actually businesses not realizing that by virtue of what I've seen, at least in my experience, is businesses not realizing that they're, by virtue of their conduct, they're actually taking these independent contractors and these gig workers, like you want to call them, and effectively turning them into employees for their businesses without them knowing it. And that's probably, I wouldn't say it's a mistake. It's just, again, happens over time. This person is working for them. They're doing a good job. So they kind of keep them there. And over time, it now becomes an employee in the business. So that's what I've seen more, as opposed to mistakes with freelancers or gig workers or anything of that sort.
So assuming I'm taking on a new person to work for me, and I'm not deliberately not using the word employee, and I want to kind of put this person on a probation, assuming 3 months, to see whether the person performs, whether I'm happy with the person, whether the person is happy with me, whether they're capable of performing the role that they say they can, and whether they're comfortable in that work environment, because it can work both ways. Sometimes you're happy with the worker, but the worker is not happy with the employment after a period of time and can't settle down. Absolutely. So would can you then take this person on as a gig worker for that 3-month period before properly registering that person?
You probably wouldn't want to call them a gig worker, but you could do exactly what you're saying. I mean, you use the right word by saying probation. As an employer, you are well within your rights to offer employment to an individual, and in their contract of employment include a probationary clause. Now, this could be up, I think the most I've seen is about 6 months, depending on the complexity of the job. If you have someone, and majority of the time it's 3 months, you take them on for 3 months, and if they perform their job functions in a satisfactory manner, they're capable, you can either then extend the contract or proceed to employ them for an extended period of time, or conversely say, look, you haven't really fulfilled the functions, we don't believe you're the best fit for the job, or they can say to you, look, I don't think I fit in here, and they could leave within that 3-month period or at the end of the 3-month period. So.
Okay. Well, we're going for a bit of an ad break, and when we come back, we'll have about 10 minutes left to explore further aspects of this, what we call gig economy. I like the term now. Now I'm getting a bit familiar with it. And we'll work through some of the maybe case studies, etc., on gig workers.
Teaching you something new every day. Radio Al-Ansar.
The chaos and destruction in the Gaza Strip is beyond comprehension. Virtually everyone is displaced, hungry, and in urgent need of life-saving humanitarian support. The Al-Imdad Foundation has been working tirelessly to address the health, nutrition, and water needs of the population. Our hospital, water deliveries, and hot meal programs are made possible with your support. Your donation, big or small, is a lifeline for those in dire need. Help Gaza survive. Donate online at alimdad.com or call 0861 786 243 for more information.
Community Nazila is proudly brought to you by Nona's Italian Kitchen, Strata Street Food, and the Magnum Capino Treat Store. Oh Allah, guide me and grant me well-being with those whom you have granted well-being.
اللهم اهدنا فيمن هديت وعافنا فيمن عافيت وتولنا فيمن توليت وبارك لنا فيما أعطيت وقنا شر ما قضيت فإنك تقضي ولا يقضى عليك وإنه لا يذل من واليت ولا يعز من عاديت تباركت ربنا وتعاليت.
Canute Nazila is proudly brought to you by Nona's Italian Kitchen, Strada Street Food, and the Magnum Capino Treat Store. Oh Allah, guide me and grant me well-being with those whom you have granted well-being.
Craving bold flavors with a twist? Strada Street Food, where neon light meets delicious bites, from sizzling burgers and crispy Korean wings, cheesy pizzas, and golden nachos. Every bite is a journey. Don't miss our famous Tremazzini sandwiches. Bring your appetite and your squad and swing by Strada Street Food, where every meal feels like a celebration.
And don't forget to tell Mommy and Daddy to take you to Capino for the yummiest ice cream and a whole candy wonderland.
Strada Street Food. Taste the vibe. Taste the tradition.
Radio Ansaar, 24/7, 365.
Business matters.
Ar-Rahman Ar-Rahim. Assalamu alaikum wa rahmatullahi wa barakatuh. If you've just joined us, it's Business Matters on Radio Al-Ansar. You with me, Anwar Moolla, and the Business Matters program brought to you by the Minara Chamber of Commerce. We've been talking to Muhammad Mirza about the gig economy. Lots of questions coming through from one particular person, so I suggest he gets all of you after the program and maybe treats you as a bit of a gig worker and then get some advice on you for all of these questions. But there's one relevant question here which I was also going to ask you, and that is that what penalties could SARS or the compensation fund impose if a contractor relationship is found to be incorrect?
Okay, I think it's a very important question. I think it's timely. So I think the most important thing I would want to get across today is that the law is fair as a starting point. As an employer, the law realizes that you're in the business of employing, firstly, to provide a service and benefit the economy. It doesn't believe that you're out to evade them or crook the system, for lack of a better word. If you can demonstrate that you were really, as a business owner, under the impression that this person was an independent contractor or a gig worker, for that matter, you would be, in a better position than you would be if you were in willful default. Now, willful default is sort of what I want to elaborate on, and that is if you do and go out of your way to evade paying SARS, avoid paying bargaining council levies, avoid, paying an employee the national minimum wage, when you know that this is in fact an employee-employee relationship, you will and you can be, and people have been hit with penalties in the past. Businesses have been fined in the past. And I think the Tax Administration Act, and the exact section eludes me, but I think it's section 234, says that you can be fined, penalized, and in fact imprisoned for up to 2 years. If found guilty and if found in willful default of the labor legislation. So you can correct your wrongs if you can demonstrate that you genuinely, didn't know, or you're genuinely ignorant. But if SARS find that you had willful actively tried to evade what's expected of you as a business owner, then you'll find yourself in serious trouble.
So let's just assume that a business gets it wrong, and a contractor is later found to be an employee. So what are the real world consequences in terms of CCMA cases, back pay, tax, UIF, and penalties?
Okay, so a bit of a loaded question, but I'll try to break it down. An employee is a contractor, now an employee. There are implications for the employer. The first would be that if this contractor can demonstrate they were an employee, they can go to the CCMA. If they go to the CCMA, it really depends on what relief they're seeking. If they say they were unfairly dismissed, they could potentially be reinstated, they could be compensated, or you could be ordered to reinstate them with back pay. Now, that's one aspect from a CCMA point of view. With respect to UIF penalties and the like, you might find yourself in a position where, if you were perhaps, let's say, working in the textile industry, if you're working in the textile industry, and which has a bargaining council, and that bargaining council has inspectors or agents who work within that sector, if they catch wind that you are operating in that sector but not registered with that bargaining council, and you haven't registered your employees, they could issue you with a compliance order to, one, register with the organization. And if they choose to do so, they could also then penalize you and ask you to pay back the penalties for those employees. And so from a bargaining council point of view, from a back pay point of view, from a penalties point of view, you could potentially pay back or have to pay back these monies.
So, Mohammed, let me take an example, and this is quite a common one. For example, if you take hospitals, right, and nurses, it's a common knowledge that many of the nurses have, for example, a job with the state during the day, working as nurses in, assuming, let's take an example, Addington Hospital, and they have a 8 to 5 or whatever. But to earn extra income, many of them kind of moonlight, so to speak, and then work at a private hospital. I won't mention any names, but I think it's general practice in the evenings and whatever. And it kind of suits these hospitals to use these people, these nurses, in the evenings, because they now probably get them cheaper, I would say, or they don't having to take them on a full-time basis. So now, I mean, what rights does the state have? For example, these are state employees, to say, well, you're not allowed to work for anybody else or do a similar type of job, which is, I would say, this is a side hustle, so to speak. Whether you would term it as a gig, I don't know, because as you described gig at the beginning, it's kind of for a limited fixed period. This could go on for a long time. So what are some of the rules that would apply to things like this?
It's a great question, and I think it's important we just unpack it quickly, because I think if I get the stats correctly, I think 4 out of 10 people, or 4 out of 10 people in the working force in South Africa are involved in some side hustle. So be it nurses, be it business people, be it salespeople, anyone, teachers, anyone, they are involved in some form of a side hustle. Now, a side hustle is not meant to replace the remuneration earned by that employee, whereas a gig worker, they rely solely on that income that they derive. So it's a separate thing. And a side hustle, I think I probably have to make the point. It's the cost of living is increasing every day in this country, and so more people are turning to side hustles to make a bit more money, and so employers probably shouldn't take the line, or probably can't take the line any longer, to say that you cannot, as an employee, involve yourself in any other business. What they can do, though, is impress upon their employees to make a full disclosure of any other business or any other activity that they're involved in which they derive an income. And so your question is, example for this hospital, they can tell their staff, this is your primary job. You're expected to work these hours. Should you become involved in another form of employment, please let us know. Failing which, we will consider it a form of misconduct, and they can take disciplinary measures against that employee. And so that's probably a practical step that the employer can take. Have a policy in place that says, if you are involved in alternative work, let us know. Don't let us find out about it. If we find out about it, it could be construed as misconduct. Better example is, though, better said, is that employees often don't tell their employer that they're involved in other type of work. And so should you realize that your employee, I'm going quite quickly and touching on different topics here because I want to cover a bit of all of it, is that if you find that your employee is sort of not performing the way they used to be performing, they're coming to work tired, they're coming in late, they're not really hitting these figures or the way they were in the past, you then can start asking some questions, and then start taking some disciplinary measures against that employee. But the key takeaway would be you cannot actually discipline your employee solely for being involved in a side hustle. You can take steps against them to find out about it, but you can't take steps to discipline that employee. There are things you can do, but that's a separate discussion and a separate topic.
We're quickly running out of time.
Yeah.
The one question that's come through from gentleman is, he obviously is in the transportation business. He said, if a driver uses their own truck but hauls exclusively for my company, does that still count as an independent contractor relationship? Interesting question.
Yeah, it does. I think it's an interesting question that probably needs to be a bit more information, but it sounds like the manner in which he would probably need to deal with that is to, I think about it now, he works solely for that. I don't think he does. Is that driver question, is it, or does it driver work
solely for him? He said the driver uses their own truck but hauls exclusively for my company. So he's obviously not employed, but he's got his own truck, and this guy probably pays him per load or something like that.
So, I mean, if I had to look at that example, I would probably say that he's not an independent contractor. He's not an employee of the company or a gig worker. I think that he's an independent contractor. I assume he has his own company. The truck is registered on his own name or the business's name, and this individual.
So that wouldn't be classified as an employee, nor would it be classified as a gig worker. He's an independent contractor.
To me, that's an independent contractor. Yeah. That's an individual rendering services, and he effectively has a major client.
Okay, he further goes on to ask, are there any industry-specific red flags like shift control, uniforms, scheduling, or truck branding, for example, that may cause a contractor to be viewed as an employee?
Absolutely. I mean, if you're wearing an employer's uniform, if you're driving an employer's branded truck, if you're carrying employer merchandise and you're carrying an employee credit card, a business card, you're actively conducting yourself as an employee of that company. So I think you'd be very mindful about how you interact and how you allow that individual to present themselves in the market.
Okay, Mohammed, final question. What practical steps would you recommend to any business owner listening today that already uses freelancers or gig workers to make sure they're on the right side of the law?
Okay, so I think first and foremost is, one, be honest with yourself.
Okay.
And that's what I tell. I mean, and I'm in great position because, my clients they are that way. They're honest with you. They'll tell you exactly what the state of play is. And this is what people need to do. They need to take a hard look at exactly what's going on. And if they do that, they'll understand whether this person is in fact an independent contractor, gig worker, or an employee. Now, the way they do that, and the practical steps I would take is, look at their contract of employment. Does their contract of employment match up with the actual work that they perform on a day-to-day basis? Look at the requirements set out in the Labor Relations Act and say, well, do the people working under my employer or in my business, do they meet these requirements? If so, they're likely to be an employee. So have a hard look at your employment contracts, look at what actual work is being performed by these individuals, and then determine whether or not, if someone had to look at it objectively speaking, is this an employee or not? And they might say, look, this is an employee. So that's the second thing. And the third thing, if you're not sure, just speak to a lawyer or speak to someone.
Okay. On that note, you want to give out some contact details that people can get you on and explore more fully this whole aspect of the gig economy and whether they're on the right or the wrong side of the law, and maybe you can assist?
No problem. Jazakallah. So, like I said, my physical address, my offices are at 98 Overport Drive in Gem Towers, which is next to Overport City. I'm on LinkedIn as Mirza and Associates, Facebook, Instagram, all of the socials. And if you have a website as well, people just Google me, they'll find me on Google.
And your phone number?
082 887 6265. But that's also...
So 082 887 6265. That's Muhammad Arman Mirza. If you got any labor-related issues that you would like to discuss with him, he's at your service. He could be able to advise you further. So, Mohammed, Jazakallah for joining us tonight, bringing us in in touch with what the gig economy is. And hopefully we are now better equipped to kind of decide on whether a person is a full-time employee or is a gig worker, so to speak, in this gig economy. So yeah, with that, I think this is the last Business Matters show for this year. From next year, we start all preparing for the souk, the much looked for souk at the end of the year, and yeah, the preparations are ongoing and in full swing. And looking forward to seeing a few of you there at the end of the year as well. But it's been lovely being on the air with you guys for the year. And inshallah, I think around about the second week or third week of January, we come back on air and we start the year again with the Business Matters programs as you know them. So it's been lovely talking to you. I hope you've enjoyed listening to the Business Matters programs. And a final thank you to our guest for tonight, Mohammed Arman. Mohammed, thanks for being here again. And inshallah, we'll get you back again at some stage on another legal matter, so to speak. But yet with that, it's wassalamu alaikum wa rahmatullahi wa barakatuh.
The title suggests many things. The important issue is the world revolves around business, society, organizations, individuals, and even religion survives and thrives because of business. Business has to encompass not just financial commodity and service transactions. It has also to include welfare, justice, empowerment, environment,